This is Barry's Alma speaking for Claim School Incorporated's blogs, Alma on Insurance. Today we're going to talk about why a swimming pool claim was sunk and why the private limitation of action provision in a homeowner's policy defeated a bad faith claim, because there can never be coverage for a pool popping out of the ground, and you have no right to sue for bad faith if there's no coverage for the loss. James H. Drevs and Patricia Henderson appealed from the order of the Law Division dismissing with prejudice their complaint seeking insurance coverage for storm damage to their real property. In a case called James H. Drevs and Patricia Henderson versus Metropolitan Property and Casualty Insurance Company, the Superior Court of New Jersey Appellate Division on April 4, 2024, applied the private limitation of action provision in the policy. Plaintiffs own property in Cherry Hill, New Jersey, which has a home and an in-ground swimming pool. In 2020, the property was insured under a policy issued by Farmers Property and Casualty Insurance Company, formerly known as Defendant Metropolitan Property and Casualty Insurance Company. On or about July 6, 2020, a windstorm and significant rainfall damaged plaintiff's home and swimming pool. Plaintiffs filed two claims for insurance coverage with defendant arising from the storm, the first claiming damage to the roof of their home and the second claiming a partial collapse of their in-ground pool. Defendant undertook an investigation of plaintiff's claims and hired an engineering firm to investigate the cause of the partial collapse of the pool. The engineering firm concluded the pool damage was caused by excessive hydrostatic pressure from significant rainfall during the storm. The insurer's claims coordinator sent plaintiff a letter denying their claim for coverage of the damage to the pool and issued a check to plaintiffs for the covered portion of the loss from the damaged roof of their home. Plaintiffs sued defendants, alleging breach of contract and bad faith in its denial of plaintiff's claim for coverage for the damage to their pool. According to the defendant, the one-year period began running again on September 14, 2020, when it denied plaintiff's pool damage claim. Defendants argued that because the complaint was filed on May 10, 2022, a year and 8 months after the September 14, 2020 period, it was time-barred. The trial court issued an oral opinion granting defendant's motion. Analyzing the issue, the Appellate Division found no basis on which to reverse the trial court's order. Plaintiff's policy is referenced in the complaint. The correspondence from the defendant denying plaintiff's pool damage claim and granting their claim for damages to their house from the basis of plaintiff's claim was also in the complaint. The September 14, 2020 letter unequivocally denied plaintiff's claim for coverage of the damage to their pool, and plaintiff produced no evidence that the parties engaged in discussions, correspondence, or any other type of interaction in the 7 months between defendant's denial of plaintiff's pool damage claim and correspondence by counsel with the plaintiff. It was undisputed, therefore, that more than 1.5 years passed between September 14, 2020's denial of plaintiff's pool damage claim and the May 19, 2022 filing of the complaint. A bad faith claim cannot be asserted by a party who cannot establish a right to payment of the claim as a matter of law, and they were unable to do so because they filed their lawsuit too late. Because plaintiffs filed an untimely complaint challenging the denial of their claim, they cannot prove they are entitled to coverage for the damage to their pool. Because even with the tolling of the private limitation of action provision until the denial of the claim, it was still too late. In my opinion, every first-party property policy or homeowner's policy contains a private limitation of action provision preventing insureds from suing 1 year after a loss. New Jersey and many states toll the running of the statute from the date of loss until the date the insurer makes an unequivocal denial of coverage. The insurers waited more than 1.5 years after the unequivocal denial of the claim, and its suit was barred. They are not without a remedy, however. The insured's lawyer knew or should have known of the limitation because he had the policy to attach to the complaint and failed to file suit within the period allowed, nor did he seek an extension of time to sue from the insurer. Therefore, the insureds may have a very good claim against their lawyer for his filing a late lawsuit. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can also subscribe to the blog at that site, and you'll be given notice of every blog posting, usually 5, sometimes 6 a week. And you will also gain access to the more than 4,750 blog postings. Please tell your friends and colleagues about the blog and the videos, and let them subscribe to the blog and the videos. And if you do and watch these videos, please click on the like button if you watched on YouTube, or the thumbs up button if you watched on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Substack publication. Thank you for your attention.